We'll start with some breaking news coming in at this moment. In a significant observation, Supreme Court has asked the government to scrap reservation quota in higher educational institutions. In its observations made yesterday, the Apex Court said that quota needs to be done away with in quote-unquote national interest. The comments were made in a judgment relating to a petition challenging state quotas in Andhra Pradesh, Tamil Nadu and Telangana. Let's go across to Anusha Soni, who joins us for more on this story. Anusha, these are observations and general guidelines that are put by the Supreme Court for the government to follow. Just take us through how binding in nature are these observations on the government.
That's a very crucial aspect, Sanjay, that you're pointing out. As you pointed out, this was a petition which had challenged the state quotas in the state of Andhra Pradesh, Telangana and Tamil Nadu. And in these states, the educational institutions, higher education institutions, especially in the field of medicine, has very strong state quotas. The Supreme Court observed that the fact that, the educational institutions are very heterogeneously spread across the country, it works against the merit. And there have been earlier judgments of the Supreme Court, like in the landmark case of Indira Sahni, which put a ceiling on the kind of reservation you have, and also laid down the guidelines that these state quotas are not in consonance with those judgments. As far as the binding nature is concerned, these are not binding, because these are obiter dicta comments. The petition itself did not question the constitutional validity certain provisions of the Constitution which allow these state quotas. But however, the Supreme Court has very mildly put it, saying we hope and we request the government and the state government to act in the national interest and issue certain guidelines.
No, Anusha, just a clarification. What you're saying is that this was a petition challenging state quotas. That is, the quotas that are implemented by respective state governments, not the central quota that actually exists. So in effect, this observation has been made on scrapping these quotas that are implemented by the state governments or at the central level.
What happens is that these state governments do have their quotas. This is in respect of the state quotas that are submitted.
Okay.
However, the legislation which governs the state quota is a presidential directive which was created by the central government. So both come into picture. So if one needs to do away with the state quota, it needs the help of the state to issue the guidelines and also the center to take some legislative steps to make sure that the Supreme Court judgment and the Constitution are in consonance with each other.
Okay.
As far as the binding nature we were talking about is concerned, it is not directly binding on any of the government.
Okay, is the government likely, Anusha, my final question before we get a comment from our studio panelists at this moment, who incidentally are joining us on the Bihar elections, but would love to comment on this particular aspect as well. Anusha, in the past also, we have seen that there are some state governments who have gone beyond the 50% cap as far as reservation is concerned, and the Supreme Court has struck that down. So that's why this question of how binding this observation is becomes all the more crucial.
Absolutely correct. So if the Supreme Court really has to see the 50% ceiling, and also the Indira Sahni judgment, it's the same judgment which laid down the guidelines about how you can impose quota, the petition has to come up. Actually, the petition which was before the Supreme Court was very limited in its nature. It did not raise constitutional questions. The court was very inclined to hear it. There is a related petition from another state which is coming up in early November, which will look into certain aspects of that, and then we'll see whether the Supreme Court takes a step further and makes certain, steps about raising certain constitutional issues in this matter.
We'll wait to hear from the government, from the Congress, from the RJD, from the JDU, from the Samajwadi Party, from the Bahujan Samaj Party. All these are political parties where these parties will have direct impact and something directly to say, because quota as well as caste is pretty much the reason for some of the parties' existence. Let's get in a word from Mr. Ajit Jha as well as Mr. Ashok Malik. Mr. Jha, how does an observation like this politically affect the prospects of any of the parties, in particularly the fray in Bihar?
Enormously, I would say, because given the fact that the main cleavage in Bihar election is on the issue of caste-based reservation. In fact, in the past, we've heard when the RSS chief made the statement about economic criteria of reservation, Lalu Prasad Yadav sort of changed the entire agenda of the elections from Jungle Raj to Mandal Raj too. So the entire election in Bihar is basically the forwards versus the backwards. So given this judgment, and by the way, I totally agree agree with the judgment, but the point is its political implications. The way the leaders of RJD and JDU is going to sell it. In a recent interview, Nitish Kumar, for example, said that reservation is part of his economic vikas agenda. He said you cannot delink reservation from the so-called vikas agenda. So given that, the timing of this judgment, I think, is going to really boil over in Bihar elections and perhaps help bigger consolidation of OBC forces as well as bigger consolidation
and also
of the
perhaps end up helping parties who traditionally talk about caste form of politics.
Absolutely, especially the RJD. I mean, RJD is going to town with this issue.
Mr. Malik, my question to you is that all political parties, cutting across their political spectrum, have been talking pro-caste and pro-reservations. Who is going to actually agree to implementing something like this? Not the central government.
Nobody. First of all, I'd like to correct Ajit. This is not a judgment. This is an arbitrary
observation.
Yes, okay. Second, by the afternoon, I expect every party would have disagreed with, politely disagreed with the judges and said this can't be done. There is a case to be made for abolishing reservations or quotas in super speciality streams such as say MD or MS or even the IIMs which Arjun Singh introduced some years ago as the HRD minister. Because the whole idea of reservations was to give people the same foundation. Especially in the case of SCs or Dalits who'd been socially marginalized for centuries. The reservation debate became a little confused, actually, I would say, with OBCs coming to the reservation scheme.
Right.
Because some of the OBC groups that have come in cannot really be called socially and education or economically backward.
Absolutely.
Okay. But having said that, I don't think any party can go ahead and say that we support this this observation by the Supreme Court. The only solution before us really is expanding capacity in higher education, which is something which this government frankly needs to do with greater urgency. We have frankly too few seats for medical education and super specialization in medicine. So too few seats.
So the solution, Mr. Malik, you are suggesting is that you have to look for a solution where merit and caste coexist.
You simply need more colleges and more seats, especially in medical education, which is the big problem area. And that is something this government needs to do.
Because quota and caste all is going to have a very high impact on Bihar elections.